I think this is interesting, and it begins to ferret out what really is the key issue that this Congress needs to focus on in regards to the matter that's being testified to. And I appreciate the witnesses who are here. You're professional and dispassionate. I think almost no one is brazen enough anymore to deny that there's a border crisis created by the Biden administration, Secretary Mayorkas. Border Chief Ortiz admitted such on the way out the door. FEMA announced yesterday the distribution of more than $290 million in congressional funding to communities receiving migrants. You don't deploy FEMA resources when there isn't a crisis. But the issue here, and I agree, it shouldn't be political theater. It's not about policy differences, can't be. The issue here is vindicating the rule of law and the constitutional role and lawmaking power of Congress. Many claim the Trump indictment is about the rule of law. The ranking member says appropriately policy differences are of a different dimension, and I agree with that. And the appropriate response for Congress is different in each case. I don't even think, with all respect to the chairman, that our focus can be exactly on dereliction in the full sense articulated, because dereliction is willful or negligent. And what we need to focus on here is whether this is not a case of negligence. If it were, the implications would be different. The remedy would be different. Incompetence in administering a federal agency is maladministration, and the recourse falls to the people alone. But intentional sabotage of the rule of law is something entirely different. It is an affront to the separation of powers, to the institutional authority of the Congress under the Constitution, and it invites another remedy, and that is impeachment. Secretary Wolf, the ranking member, attacked actions by the Trump administration, but your statement, really elegant, 10 pages, covers a lot of ground. I urge people to look at it carefully. You point out that you were attacked for by the ranking member, these were exercises of authority specifically granted to Congress. Take migrant protection protocols, remain in Mexico. You cite 235B2C of the INA. In the case of an alien described in subparagraph A, that's somebody who would have right otherwise to asylum, claim of asylum, who is arriving on land from a foreign territory contiguous to the United States, the Attorney General may return that alien to that territory pending a proceeding under Section 1229A of this title. So that's exactly what you did. Whether somebody said you did it in the exact way or if you want to challenge House, you were exercising an authority. Same thing with safe third country agreements under Section 208A2A, and I won't read all that. But here's what you point out, the violations of law, several of these found by federal district judges at this point in time, by the catch and release, ignores the mandate to detain or make them wait, an asylum applicant wait in Mexico. That's been judged by Judge Wetherill in Florida to be unlawful. The use of notices, what are they called, NTRs, Mr. Wolf?
Notices to report.
Notices to report. So you don't even have any formal commencement of removal proceedings, which a notice to appear would be, setting a date, even though you never get to them. They don't even do it. They just let them go with NTRs. The exercise of authority to adjudicate asylum by DHS officials, maybe Mr. Edlow, you may have pointed this out in your testimony instead of in the Department of Justice where that power is reserved. An interior non-enforcement policy, Mr. Wolf, you pointed out the 100-day deportation freeze. Judge Tipton said that was illegal. Subsequent enforcement priorities established that exempt 99% from the threat of deportation. Secretary Mayorkas declaring that illegal presence alone is not grounds for removal. More than 1 million in the country subject to final removal orders, and they've said they're not going to remove them. So I'm just going to leave my last minute to you, Mr. Wolf, but I see what we're talking about is intentional sabotage of the rule of law as set by Congress, and that's a different ballgame.
It is different. It's not just about whether or not illegal aliens can claim asylum, as was talked about here earlier. As you indicated, at least in my written testimony, there's 7 different instances where I believe the law is not being faithfully executed, to include the categorical parole, which was the last one there.
And I didn't get to that.
Which is at ports of entry, which is at the heart of all of this. You know, to have asylum needs to be an urgent humanitarian benefit or advantageous somehow to the United States. Simply paroling up to 360,000 individuals, which is what they are on track to do per year, violates the letter of the law. It's very clear.
final point here is that it does fall to Congress, as well as these judges, fall to Congress through the impeachment power to decide whether the law has been intentionally flouted. I yield back.